territorial jurisdiction. By territorial jurisdiction, we are calling to mind that every court has its own territorial limit over which it can exercise jurisdiction. Territorial limits over which it can exercise jurisdiction. And that's why, like in respect of magistrate courts, you have magisterial districts. Magisterial district simply means the territorial jurisdiction are shared. Territorial jurisdiction are shared between locations with respect to magistrate court matters. Territorial jurisdiction, so that's why you have magisterial district. For instance, in Aba, we have the Aba North Magisterial District, and we also have the Aba South Magisterial District. And the same thing also applies to Manga here. And in addition to that, we have Isiama Magisterial District, Usisiama Magisterial District. So what it implies is that the magistrate court in Aba South is limited to matters arising within the jurisdiction. You cannot assume jurisdiction with respect to matters arising from Aba North, Isiama or Usisiama or any other district. So in terms of High Court, you have the judicial divisions. A judicial division is a territory over which a particular High Court situated within that jurisdiction can exercise authority over criminal matters, since what we're doing today is criminal litigation. Okay. Now, sometimes you may have situations where issues may arise, and the issue of determining which court has the territorial jurisdiction will be an issue for determination. So when such issue arises, the best thing to do is to look at the delineation to ascertain which particular court has jurisdiction, especially in civil matters. Territorial jurisdiction in civil matters are sacrosanct. In other words, there is just no way you can assume jurisdiction if you don't have that territorial jurisdiction. In civil matters, it's sacrosanct. There's no two ways about it. The only aspect where matter arising from another jurisdiction can be tried by court from another territorial jurisdiction is when the chief judge of the state has done what? Transfer the matter to it. But in criminal matter, we are going to see a lot of exceptions. Some of the times, you will see a court assuming jurisdiction over a matter, despite the fact that the crime was not committed within the location of that very court. The law has made it so. And we're going to look at some of the provisions of the law that has permitted such practices. And the idea is to ensure that the crime rate in the society is cut. And then secondly, that a criminal does not go scot-free on the basis of technical issues such as jurisdiction. You understand what I'm saying? You know, so that assuming somebody comes to one jurisdiction and kills a person and runs to another jurisdiction, and you say that this other jurisdiction has no powers to try him, why? Because the murder occurred in another jurisdiction. Do you think that will satisfy the yearning of justice? Do you think it will ensure the safety of the society? It will not. So that's why the law has created some of these exceptions. So we'll quickly look at some provisions in support of the rules on territorial jurisdiction. The first one is section 93. I'm looking at Abia state laws now. So I will just paraphrase what it's talking about. It's purely laying down the rules on territorial jurisdiction. And this place is saying
subject to powers of transfer contained in the enactment of law establishing the court, the place for the trial of an offense shall be in the division or district. This is the general rule. This general rule is subject to the powers of transfer given to the chief judge or to any other authority. But the general rule here is that a court has jurisdiction in respect of the following. One, where the offense was committed. So if the offense was committed in jurisdiction A, that jurisdiction A is the location that has what? The jurisdiction to try it as a general rule. And then also, closely related to this is another authority given to this court where the offense has been committed. The court, if part of that offense was committed in that jurisdiction, that particular court can also do what? Exercise jurisdiction. So I now use present tense so that you understand me better. If an offense is committed within, let's say, Aba North Magisterial District, the court that will try it is the court at where? Aba North Magisterial District. Now this is one of the powers. The second powers or authority conferred to any such court is where the offense is partly committed. Where the offense is partly committed in a jurisdiction. The court within that jurisdiction can do what? Can also try the offense. What you consider is that act committed in a particular location or jurisdiction. Does it constitute an offense? If it constitutes a complete offense, then an offense has been committed and the court within that location has what? Jurisdiction. If it started there but did not finish there and finish elsewhere, then you can say that it was partly committed in a particular location. Okay, now let's go back to example. Stealing, for instance. Someone wants to steal a car. Maybe he started tracking the owner of the vehicle. Let's say he started tracking the owner of the vehicle from Aba North. And then eventually, by the time the person entered into Aba South, this person who wants to see the car finally succeeded in taking away the car from him. While he was in Aba North, did he commit any offense? That was when that mental element was constituted. The only thing that was missing was what? The accessory offense. Do you understand? So even if at that, he is stopped and somebody noticed, maybe the detective noticed and arrested him for that, he would have been charged with what? Attempted stealing of a car. Do you understand? Right. The same thing can also happen in conspiracy. Conspiracy is one whole offense. All right. If somebody conspires with other people and does not join in the execution of the offense, is the person guilty? Yes. Can the person be charged? Yes. The person can be charged. Yes. Why? Because conspiracy is one body of an offense. Now, conspiracy can start from Aba North and end in Aba South. Maybe someone was planning to commit bank robbery. He meets a friend in Aba North and they discuss the modalities. And this person said, I know an insider. We need an insider to make this job work. And they say, where do we find the insider? And the other party says, let's go to Usisioma. We'll find an insider there. They go to Usisioma, got the person, discussed with him, and he agreed. What are we talking about now? Conspiracy. Commenced at where? Aba North, and ended where? Usisioma. So each of these jurisdictions will have a right to do what? To charge and try any of them. Granted the fact that a good number of times it may not be possible to know when an offense is partly committed. That was the problem we were having, trying to connect it. So it's a bit technical, but the question you ask yourself is that an act that was done within a particular location, does it constitute any offense known to law? Because if you say the person has done an act, that an act must do what? Constitute an offense known to law. If it's not an offense known to law, then the person has not done what? Has not done any wrong. Okay. And that is why if a judge is convicting somebody and the judge appears speculative in his judgment, the judgment will be done what? Set aside. Example of that is during the conviction of Fela. Somebody still remember? Where the judge said he was convicting him for obvious reasons. And the Court of Appeal said there's no offense known as obvious reasons. So that offense must be an offense done what? Known to law. Alright, we move on. Second power, or the third power conferred on the court in respect of entertaining a criminal trial is where the consequences of the offense ensued. Where the consequences of the offense ensued. Where the consequences of the offense ensued. In this regard, who can give me an example of consequences of an offense? Where the consequences of an offense ensued. Consequences of an offense. What do you understand by that? Where the consequences of the offense occurs. Maybe we just use that word.
In my own thinking, I think what is meant by the consequences is if the person steals a car from Aba and the person finally got arrested in that month, that is the consequences of the offense.
Okay, he's talking about the consequences by way of he has stolen a car somewhere, got arrested somewhere else. That is good. I agree. Any other way of interpreting the word consequences? Consequences of the offense.
Let's use the car snatching also. Let's say someone snatches the car. Then at that process of, let's say, trying to reverse or get away with it, he knocks somebody down.
We are talking about two offenses now. You know, if maybe he knocks somebody down, is that an offense? If somebody stole a car, even let's say during an armed robbery, he stole a car and in a hot chase he knocked somebody down. Knocking somebody down, is it an offense? Is it an offense? Knocking somebody, let's talk now. What offense does it constitute? Who told you he was reckless? What if the person was crossing without looking? Does it constitute an offense? Nobody's answering me. Have you forgotten criminal law? Either. Now, the answer is yes or no, or yes and no. But it's arguable. Yes, in the sense that if you go about it by the egghead rule, a person is taken to intend the consequences of his action. You understand? So, in an attempt where somebody has gone to commit a crime, whatever wrong that occurs out of his activity is the same transaction. And that makes him what? Guilty of that. Right, that makes him guilty of that. Now, no, in the sense that, assuming he was trying to get away, and someone recklessly or negligently runs across his way and he hits the person. If by traffic law, he has a good defense, that one is apart from what he has done. So that is why, because some offenses, some things like that are what? They're severable. You have to severe it, not the one that constitutes an offense, a criminal offense, and the one that constitutes what? Civil wrong. That he has, in addition, done something that constitutes a civil wrong, does not mean that that civil wrong will be taken as what? Criminal offense. It will not. Now, another power is where the person against whom or people in respect of which the offense was committed is found. having been transported by the suspect or by a person knowing the offense. Do you understand this power? Did you understand this? Somebody had earlier given an example here now. We have this power now is talking about, I'm just calling it power so that we understand it better. It's talking about subject matter or the human being. An offense has been committed somewhere, a property has been stolen, and then later found somewhere. Maybe a car snatched for getaway purposes, and this car was found somewhere else. Right. As far as that location is concerned, that location has the authority to do what? Investigate the matter and try the matter because the stolen car has been found within its own jurisdiction. If it was a human being that was kidnapped, at the point where the human being was found, that court will do what? We exercise jurisdiction. It's simple. So that's what this provision is talking about. Where that subject matter or the victim of the offense is found, that very court will do what? Have jurisdiction to try it, irrespective of the fact that that person was transported from somewhere to that very present location. So it doesn't stop the court from assuming jurisdiction. And then we look at subsection 2. Subsection 2 of section 93 says, an offense may be tried by a court having jurisdiction in any division or district in any of the following circumstances. More powers you may call it. Sub 1, when it is uncertain in which of the several divisions or districts an offense was committed. Where it is uncertain, the last bus stop of the offense, or where the person is found, or the vehicle is found, or the criminal is found, will be the court to do what? To try the person. Remember, this looks or envisions a situation where many districts or locations might have been involved at once. And nobody can say as a matter of fact which particular jurisdiction is the jurisdiction where the offense occurred. All right. Let me also give us an example. When somebody's car is snatched and later recovered, you don't just, upon your car being snatched and you are safe, what do? What are you expected to do? You report to the police. Why would you report to the police? Why would you report to the police?
There are two reasons why you report to the police.
Okay.
One is that since the stolen vehicle, for the police to aid in recovering it in case they commit something. Then secondly, if that vehicle is used to commit a crime, you might be indicted.
No, but the first suspect is not the vehicle. So these are two major reasons. And then again, if this vehicle is found and there is no report made, it will be difficult for you to exonerate yourself. So that's why you have to first of all do what? To make that report. I remember sometime, I think when I was just 2-year-old in practice, I was coming back from Ohafia, and then because I met somebody I knew very well, he's late now, so I decided to give him a lift. I'm just a young boy, I had nothing to do with myself, I had all the time. So I asked him whether he was about going. He said no, he wanted to treat himself, maybe by nature, blah, blah, blah. I said, okay, let me drop you. I said, the place is far, it's up on your so. I said, no problem. So I took him there. After he treated himself, I took him. By the time we were going back, it was already late. So while we were getting close to Uguroba, and that man happened to be a driver. So as we were approaching Uguroba, so by the time we do the bend, we just discovered the road had been blocked. I wasn't even thinking of anything. And the man just told me, be still, don't be afraid. I was like, what is it? So I had never encountered armed robbers before now. That was my first time. So he told me, armed robbers. Because when he told me armed robbers, and before he could mention it, they had already opened the car. I said, lie. And I was still wearing my beard. So they laid us down. search us. Then another person, one of them just approached me. How much do you have? I think I had 12,000, and I had already bought fuel, and I couldn't even remember how much I had again. I told him it's 12,000. I thought, yeah. So he searched my pocket, took it, and when I came back and talked his gun, I will kill you. You're a thief. You lied to me. Imagine. So why did you lie to me? Why did you see it now? It's not even that. And I was stuttering. I couldn't even remember how much I had. And the other boy just came running. Carlo, don't touch it. Don't shoot. Don't shoot. So much later, the guy told me, Barrister, don't be afraid. We want to borrow your car. And the way the guy spoke, I just knew he was a student. And that really hurt me. I hadn't started teaching, I wasn't yet a lecturer, but it hurt me, So he said, don't worry, we are returning. I wasn't even bothered about the car. My own is to return safely. So after the operation, then someone touched me and said they have gone. So I said, how are we going to go now? It's okay. I was mindful of him. So we started trekking that very night too. There's this uncompleted, sorry if I'm telling something. So there's this uncompleted story opposite former Jerry's house, the one that was burnt. For everybody from that location will know what I'm talking about. As we were approaching there, I look at my car, and that was just a kind of, all I could say, that was what I achieved in Enimba. The message is 2:30. So I just saw the car. I wanted to rush. Please, I spotted. So he said, just don't talk. So he dragged me into the bush. So and he was muttering something. So somebody can be a graduate and you have sense. So I didn't understand. So much later he said, don't you know that they are doing this thing with the police? But I'm sorry, not your police. So it was there, and we waited inside the bush, and we were watching. After discussing with the police, they exchanged those guns. I'm telling you what I saw. Was taken back to the police pickup, and my car now left towards my village side. So we slept in the completed building. Around 5:30, we managed to walk inside town. You can imagine the distance, looking for police station to report. He wanted us to go, but I wanted to report. So when we got there, the first thing the policeman that saw us, hey, Charles, I have brought these people, sorry, and they didn't stop. I said, why am I telling you sorry and you're not talking? Am I the person who robbed you? I said, sir, I didn't even say I was robbed. So there is this particular policeman who was just giving me a sign not to talk. They refused to record me, and those people were hanging around to know what I would say. The man said, just stay here, don't say anything to anybody, let me get you water. So the man went out. For over 30 minutes, by the time he came back, the other policeman had already left there. So he told me, look, I am an Assemblies of God church man, and I don't believe in what they are doing here. If you had made statement there, it would have been terrible. So to cut a long story short, he finally volunteered, I volunteered my statement and left. So when I left, went home, took the vehicle in the house, went back to Aba. After 3 weeks, so I got a message. Somebody came to my principal's office, dropped a note that I was wanted at Obingwa, Eastern Ongwa police station. I said, why should I be so wanted? So my principal wasn't around, so I had to go there. By the time I got there, they welcomed me. They said, we recovered your vehicle. So and immediately the man was bragging, we recovered your vehicle. I knew he was thinking of money. Then the woman, one of the lady police said, I recovered one. I just knew something was wrong. They were just like fighting themselves. So the woman called me and said, so I got to tell him the truth. That woman is from Akwa Ibom. He said the car was parked in front of the station with a letter saying we robbed this car from a lawyer whose complimentary card is found in the car. Please return this car to him within 48 hours. I was just, and so it was even the robber that recovered it. So eventually, when I came, they started talking about money. I told them I was still, trying to, get through the hallucination that I wasn't taking it. They want to let them take the car, not even care. So when they didn't see me for 1 more week, they took the car to State CID. So I was invited. So when I went to State CID, they started playing their game. The legal officer, who is a lawyer, very painful to say that, also started asking for money. And so the armed robbers didn't even ask me for that kind of amount. Much. And let you, my colleague, I have red eyes, it comes out when necessary. So I was really angry with him. So I left him. When I was about going, I saw someone that looks like someone I know. They had lived in our compound. The dad worked in the railway. I approached him. I said, "Hey, John." And he was the assistant commissioner of police. So I introduced myself. He was so happy seeing me. Took me to his office. And then asked me what the matter was. I told him everything. It's okay, no problem. He called the OC legal, and then asked him, and when I also saw car that was recorded, he said, yes, the man came, and the man was, he doesn't want to. The ACP asked him, was it a man or a boy? He said, yes, the boy came and he was just behaving childish. So the ACP said, Mr. We've heard of him. Said, okay, no problem. What's the state of the car? He said the tires are defective, so go and pump the tire. What about fuel? Say there is no fuel, go and fuel the car. We are going on investigation. So immediately you finish and just report the SI, I finished. Just Collins, take your car. So that was just So if those boys had been caught, in Obingwa, irrespective of the fact that the act took place within Ohafia local government jurisdiction, Obingwa would have done what? Had the jurisdiction. You understand? Now, assuming this process took place, went to Obingwa, back to Umuahia, and Umuahia was finally got any of them, Umuahia would have done what? Tried them, irrespective of where that offense had occurred. So we are talking about offense that has occurred in series of jurisdiction that we may not even be in a position to determine where in particular that offense was committed. And then the second aspect says, when an offense is partly committed in one division or district and partly in another, we've already talked about this. In the first one, we talked about magisterial district. Yeah. This one now we're talking about judicial division, so they are the same thing. So if an offense had occurred at the Super Judicial Division, and then that's partly and then fully consummated in another jurisdiction within Umuahia Judicial Division, the court in Umuahia can do what? Assume jurisdiction, as well as the court at where is Super Judicial Division. When an offense is continuing in nature and continues to be committed in more divisions or districts than one, let's just stop there before we move to the other one. When an offense is continuing in nature and keeps occurring from one division to another, each of the divisions or districts can handle it. What type of offense can this be? What type of offense can have that kind of multiplier effect? You continue committing it from one jurisdiction to another. Kidnapping, tell us how. Tell us how. How can it occur in several jurisdictions? How can it occur?
An offense can be committed in Aba or hillside then you can also, the same offense or the same people can also.
The same kidnapping now that you're talking about.
Can also be committed in Osisioma.
How?
Due to change of location, because it might be that the over hillsides where they keep their kidnapped victims have been exposed, something of that nature. Then they will now change sites.
So when they move location, I agree with that. Any other offense that can be continuing in nature from one location to another, just like that. Can you think of any other location, any other type of offense? Another type of offense. Robbery can also happen like that. You understand? Maybe when they decide to rob series of banks in different locations, as a result of a single conspiracy theory. And then you also remember the case of this, I remember it and cited in class, the case of this boy that robbed a bullion van. They pursued that bullion van from Lokoja to either Gauzo in Sokoto State. They continue pursuing it. So each of those things, every state they pass, every location they pass, constitutes the continuing nature of that single offense because it was still one transaction, one criminal transaction. Okay, so we look at sub-3. When it consists of several acts committed in different divisions, several acts committed in several different jurisdictions, can we think of that? The crime now consists of several acts committed in several jurisdictions. Any example of that? I was talking about like inchoate crime, where a particular offense has different elements. And these elements were not all committed in one jurisdiction. One in one jurisdiction, one in another, just like conspiracy we have talked about, maybe robbery or kidnapping, moving from one location to another. All right. An offense committed while the offender is in the course of performing a journey may be tried by a court in the division or district through which the defendant passed, or in which the chain in respect of which the offense was committed is situated. Two major things here. If the offense is committed by an offender who is on a journey, like all these night bus people, maybe they may just like our driver continue going and they were just robbing everybody. It could also be that they are in harmony with the driver. The driver will just pretend and then they just continue robbing to make sure that they ransack everything. Quite unlike those people that will stop the vehicle at a particular location and begin to rob their victim. But here he's talking about a situation where the defendant was on a journey and committed offense. So every location he passed through had the jurisdiction to try the matter, or where the property stolen is kept or found. So every such court, either magistrate court or high court, will have the jurisdiction to try the matter. Then again, where any cause is commenced in any division or district, other than that in which it ought to have been commenced, it may, notwithstanding, be tried in that division or district unless the defendant shall object at or before the time when he is called upon to plead or state his answer. This is very, very important. This place is talking of a situation, we normally see this happen almost on a daily basis. Let's say, for instance, an allegation of an offense happened or took place in Aba, and then the victim decided to petition Zone 9, which is a different location and different judicial division. Now, let's also assume that after investigation, Zone 9 police headquarters decided to try the matter in Umuahia, did you think the Umuahia court would have jurisdiction?
No,
Why?
because Umuahia certification is not the locus where the offense was committed. I had an example myself. I had a problem with a level of attempted to somehow got my daughter. So I reported the matter at the area command.
Okay.
For a week, the approval was only with my petition. So the IPO there advised me to come. I came here and met my colleague. He gave me further directives and I petitioned here. So we investigated the matter of arrest and the matter went wrong. They still have to take it back to Aba.
So why did they take it to Aba?
Because when the incident happened, took place, the offense was committed, was at Aba Judicial, Aba Judicial Division.
All right, let's now look at the law. Before, that was the law, that if this matter happened in Aba, if the act took place in Aba, and the report was instigated as Zone 9 in Umuahia, all Zone 9 needed to do was investigate, refer back to Aba for charging, or Zone 9 can charge, but arraign in Aba.
Yes.
Right, but now, the rule is that Zone 9 can arraign where? In Umuahia, except the defendant objects. So if you don't object, if the defendant fails to object, the court will do what? Assume jurisdiction. The court will assume jurisdiction. You know, most of the times, people get to suffer this because either they are not properly advised or their counsel failed to do the needful. You know, one, because you have to consider the fact that the defendant has the constitutional presumption of innocence until the contrary is proved. And then you also do not have to subject him to unnecessary inconvenience. You know, like leaving his place to come to Umuahia, he may not have transport, and any day he doesn't come to court, the bail will be revoked. Do you understand? So because of that, the court will listen to hear whether there will be any objection for the trial of the person before the court. If there is any objection, the court will simply do what? Grant it and transfer the matter to Aba. But when there is no such objection, the court will take it that the person has done what? He has waived the right to raise objection as to being tried, despite the fact that that court lacks the territorial jurisdiction to try the matter. And then we'll look at sub 5 of section 93. The Commissioner of Police shall ensure that one or more armed policemen are posted to provide security. So this one is a bit of what we're saying. But this one has to do with what? Both the protection of the court, the protection of the complainant, and the protection of what? Witnesses. All right. And section 94 deals with offense commenced and completed in different states. Different states. We are now moving basically into states. The other aspect of section 93 was talking about magisterial district, different types, and different judicial division. But section 94 handles offenses that are trans-state in nature. Sub A, where an offense is commenced in the state and completed in another state, or is completed in the state after being commenced in another state, the suspect may be dealt with, tried, punished, as if the offense has been actually or wholly committed in the state. What state is he talking about here now? By saying in the state. Which state? The last state. So if the offense commenced at Akwa Ibom, and maybe the person escaped and was later found within FCT. FCT is the state in question now. FCT will do what? Will try him. If he was found in Sokoto state, Sokoto will do what? Will try the person. Then the powers of the chief judge to decide question as to court of inquiry or place of time. Section 95 says that where a question arises as to which of the two or more courts of the state ought to inquire into or try an offense, it shall be decided by the chief judge. So if, like we have said, an offense is alleged to have been committed in another state, but the culprit has been apprehended in another state, and let's say that very state where the offense was committed happens to be desirous of having the suspect brought to its jurisdiction, but the state where the culprit has been found is disputing it. Where such a situation arises, the chief judge will be the person to do what? To determine it. And then what would want to ask? Why would two states be struggling over prosecuting a particular person? Is it possible? Is it possible? It's just like Igori. Especially where large amount of money is concerned. You know, that reminds me of the situation where Igori's loot was repatriated, and Malami insisted that the money belonged to federal government. And by belonging to federal government, he will now take his own share as the chief law officer that started the process. And you know what you will do? You just gather his cronies and tell them to ask for 10%, and he will be the one to pay. So that elicited a lot of furor, and I think the state also went to court. Possibly they resolved out of court. And I was asking myself, why on earth would the federal government think that the money belongs to it? I mean, this was money already disbursed as an allocation to the state. And one person took it. You have called the person, thank you, that's a good job. And they are now saying the money should belong to you. No. If you are asking for compensation, maybe for the trouble you took, the expenses you incurred in getting this loot back, it would have been a different thing. So we are talking about a situation where we have such important criminal. And this important criminal, two states are involved. One state wants to try, the other says no, we are the ones to try. So when such a matter arises, you go to your section 95 and take the matter to whom? The chief judge. Which chief judge now? Which chief judge now are we talking about? There is no chief judge of the federation. Which chief judge are we talking about? The chief judge of the last state, the state where the accused was apprehended, the defendant. The chief judge of that state, not even the state that is saying this matter emanated from us, and also want to discuss what is the propriety of that. Why wouldn't the law have said, bring two of them together, bring the two chief judges together to brainstorm? What if this other chief judge is also an interested party? So this provision of the law, do we think is what it should be, or should something be done about it? Now, the power of the chief judge to transfer, section 96, power of the chief judge to transfer. The chief judge may, where it appears to him that the transfer of a case will promote the ends of justice or will be in the interest of the public peace, transfer any case from one court to another. So you see the discretion that the chief judge has there, but this discretion is not something that is open-ended. It has, it has heads. What I mean by heads, referral points. Things that must happen or things that the chief judge must take into consideration before the case is transferred. One is to do what? Promote end of justice. Secondly is what? Interest of public peace. Interest of public peace. So where this happens and a petition is lodged with the chief judge seeking for the transfer of any matter, the chief judge will do what? Will transfer the matter if satisfied of the existence of one or two of these reasons. Now again, you may want to wonder what ends of justice mean. When can it be said that the transfer will meet the ends of justice? Is it possible to be abused? This type of power, is it possible to be abused? Especially when you talk about the interest of public peace. Who determines the interest of the public peace? Is it the judge, the chief judge, who may as well have been cut off from the public feelings? He doesn't even, he doesn't ride bicycle, he doesn't come to the public, mingle with the public, so how would he know what the interest of the public is all about? Sub 2, the power of the chief judge referred to in subsection 1 of this section shall not be exercised where the prosecution has called witnesses. So if the matter is part hard, forget about transfer. Once a matter has commenced, hearing has commenced, there will not be transfer. Mind you, this is a criminal matter. There will not be any transfer. But don't you even think that the hearing of the matter is likely to expose reasons for the matter to be transferred? Do you agree with me? Because for some courts, especially those that are very mean, you will not even know their mind until the trial starts. Some magistrate or judges will be to make you raise objection. You say, I'm the one, I'll come and write it now. They will behave as if they are the court. Okay, sub 3, where the chief judge is to exercise this power subsequent to a petition, the chief judge shall cause the petition to be investigated by an independent body of not more than 3 reputable legal practitioners within 1 week of receipt of such petition. I think this is a good innovation. It has never been in our law. It was not part of our jurisprudence earlier on. So what this place is talking about is that if there is a petition to the chief judge, asking the chief judge to transfer the matter, maybe this my brother is having a matter, and is not satisfied with the way the magistrate or judge is conducting the matter, he can write a petition to the chief judge seeking that the matter be transferred to another judge. Now, this place is saying that upon receiving that letter, the chief judge will consult a panel of 3 reputable lawyers to look into the matter and report to him. 4, the investigating body shall submit its report within 2 weeks. Okay, that is that. So we will now look at any other provision that concerns territorial jurisdiction. Transfer of case where cause of complaint has arisen out of jurisdiction, very important, section 99. Section 99 says, where a suspect is in custody and the court directing a transfer thinks it expedient that the custody should be continued or not, where he's not in the custody and he should be placed in custody, the court shall by its warrant commit the suspect to prison subject to such security as it may deem appropriate in the circumstance until he can be taken before a court where the cause of the complaint arose. So the subheading here runs contrary to the provision. Then 100, I'll still explain it. Notwithstanding the provisions of sections 93 to 96 of this law, a judge or magistrate of a division or district in which a suspect is arrested and charged with an offense alleged to have been committed in another division or district, or where is in custody on the charge, or has appeared in answer to the summons lawfully issued charging him with the offense, may, where he considered that justice will be better be served, having regards to the accessibility and confidence of the witnesses, proceed to hear the charge, try and punish the suspect as if the offense had been committed in that division. The offense referred to shall, for all purposes, be deemed to have been committed in that division. So I just summed it up. This place is saying that where an offense is being tried by a court within the location where the suspect was arrested or found, the court can go ahead to try the matter to its conclusion despite an application for transfer. Are you following? If the court thinks that it's expedient to try the matter there, because maybe that is where you have the witnesses. That's where you have the exhibits, maybe immovable exhibits. So where that occurs or is the situation, the court may not bother with transferring the matter to another court, but will now do what? Try the matter as if the matter originated from that jurisdiction. And finally, Section 101, assumption of jurisdiction. Where a case is commenced in another division or district than that in which it ought to have been commenced, the court may assume jurisdiction in accordance with the provisions of 99 of this law, and all acts performed and all decisions given by the court during the trial or any other process shall be deemed to be valid in all respects as if the jurisdiction had been assumed prior to the performance and giving of the decision. So this section 101 gives birth to section 100. It's simply saying that a court taking into consideration the likelihood of the witnesses being within the jurisdiction, the likelihood of the evidence sought to be tendered, or the evidence that will assist the court to arrive at a just decision, being within the jurisdiction. The court can do what? Fall upon section 101 to do what? To assume jurisdiction and behave as if that offense was committed in that very jurisdiction.